Hey everybody, some news. It's not Wendy's arrest, but Charlie's appellate attorneys filed his reply brief. So thankfully we have Mona and Nadine here. Thank you guys. How are you?
We're good. Good to see
Um,
you guys.
Good to see you and good to see our community. Very cool.
Yes.
Yeah.
Yeah. So we'll get right in because this whole thing is 67 pages, but you guys don't have to read the beginning with the contents and stuff. And they have graciously agreed to read so people don't have to hear me and my shaky bad voice and I'll be complaining and stuff as usual. Well, first of all, they filed this motion to accept an enlarged reply brief because there are procedural rules as to how many words they can have in these types of briefs. So he's saying that the limit is 4,000 words, but Charlie's attorneys want to submit something that is 11,219 words. I'm like, what? That's like more than twice as many as the limit gives you. But the state's attorney consents to it, so I think they probably will just go ahead and say it's okay. Yeah, so I'll take that off the screen and then flash the actual reply. Okay, you guys ready?
Ready?
Who wants to start first?
Mona can start if she
Mona?
wants.
Okay.
Now she's muted.
Okay.
she's
So,
she's kidding us.
okay. You okay? Feel free to go ahead. Oh, so citation.
We're not hearing you, Mona.
Mona, we
Are
can't
you doing
hear
that on
you.
purpose?
Uh-oh. she, I think she's muted because I see that little microphone.
Oh,
Okay.
I thought she was playing a joke on us.
Uh-oh. Okay, I still can't hear you. Oh my gosh. Uh, technical difficulties.
Okay,
Well,
I'll start.
okay, well, Nadine will read, and then when she takes a break, hopefully Mona can be heard.
I'm
Please.
not a
Oh,
Luddite.
there you
I
go.
got it.
There you are.
I got
There you
it.
are.
It's called settings.
Yay. Okay, go
I
ahead
really
then.
thought you were going like
Joking.
pretending.
No, what happened was my phone decided to jack the camera's mic for some reason. I blame it on Charlie and Wendy. Okay,
Yes.
Yeah, you
I'll
can blame
start if
everything
that's
on them.
okay,
Yeah, go
and then
ahead.
we'll see how it goes.
Hmm.
Argument and citations of authority. The state's answer brief attempts to avoid the merits of appellate Adelson's constitutional claims by failing to engage with the fundamental legal principles that underlie his arguments. Much of the state's discussion focuses on minor procedural points or characterization of isolated facts rather than confronting the broader constitutional concerns at stake, namely the right to a fair trial by an impartial jury and the right to a fair and complete presentation of a defense. The state's lack of substantive engagement with these core issues exposes the weakness of its arguments. Consequently, the state's brief does not demonstrate a sufficient basis for affirming the rulings that impacted the fairness and reliability of the proceedings below. For these reasons, all what how many pages? 66 pages of reasons. Each issue is addressed in turn with careful attention to the record and the law. You want to go, Nadine?
Sure. Let me open my screen. Number one, the trial court erred by denying appellant Adelson's motion for a change of venue. Of course. Appellant Adelson continues to rely on the argument as outlined in the initial brief regarding claim. Number one, appellant Adelson maintains that after attempting to select a jury, it was clear that it would not be possible to convene a fair and impartial jury because of the extensive pretrial publicity in Tallahassee. The trial court's error in failing to change the venue violated appellant Adelson's rights under the United States and Florida constitutions. See U.S. Constitution Amendment, blah, blah, blah. The state argues that appellant Adelson waived his venue argument by accepting the jury without objection. In reply, appellant Adelson relies on Manning v. State, blah, 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 despite the state's assertion that, quote, Adelson's case was nothing like Manning, unquote. Answer brief at 30. In that case, the Florida Supreme Court reversed on the venue issue, where, quote, the defendant did not exhaust his peremptory challenges and accepted the jury without renewing his motion for change of venue. In fact, defense counsel Robert Murrell, prior to accepting the jury, stated, quote, it would appear to us that we have a fair and impartial jury here. Nonetheless, the Florida Supreme Court held that, quote, the motion for change of venue in this case was amply supported by evidence which established that the community was so pervasively exposed to the circumstances of this incident that the defendant could not secure a fair and impartial trial in Columbia County, unquote. The court cautioned each case must be judged on its own merits as to whether, under the circumstances, the inhabitants of the community are so infected by knowledge of the incident and accompanying prejudice that jurors from the community could not possibly try the case solely on the evidence presented in the courtroom.
What they pay all that money for that guy then?
What was his name? I forget. The New York guy.
Meanie Dubin, the boxer.
Oh, Josh Dubin? What?
Yeah.
Josh Dubin.
Wasn't he the $1 million
the jury consultant? Yeah. From New York. Yeah, that made Charlie think he was going to win somehow.
Mm-hmm. Okay. Go ahead.
Where were we? Further, because, quote, our state and federal constitutions guarantee to criminal defendants a right to a fair trial by an impartial jury, unquote. The venue error is structural. That is, the denial of the motion to change venue is the injury itself and affects every subsequent moment of trial. The state's procedural argument is therefore incorrect as a matter of law. While it is preferable to renew the objection at the end of jury selection, renewal was not required here, just as it was not in Manning.
What year was that? Did you catch that, Judy?
I didn't.
I'm like, are they doing like a 1920 case?
Right? 79.
Oh, okay. Well, that's stupid.
Yeah, 1979. Okay. But keep reading because they're saying things have gotten worse these days in terms of publicity.
Well, it has with social media.
Yeah.
Okay. Go back down. Where were we? Additionally, the state argues that appellant Adelson's oral motion for change of venue was legally insufficient because Florida Rule of Criminal Procedure 3.240 requires the motion to be submitted in writing. Answer brief at 20. Notably, in both cases cited by the state in support of this assertion, the Florida Supreme Court reached the merits of the venue argument. See Provenzano versus State. Provenzano? That's from 1986. Thus, and 1988. Thus, Florida law does not require strict technical compliance with Rule 3.240 for an appellate court to review a venue ruling where the trial court was aware of the objection and denied relief, i.e., what matters is whether the trial court was presented with the issue and had the opportunity to rule on it. Here, the trial court expressly entertained the oral motion, asked a question regarding counsel's suggested alternative venue, and proceeded to trial knowing that appellant Adelson contended a fair jury could not be drawn from Leon County. Appellant Adelson asserts that appellate courts retain the discretion and, in appropriate cases, the obligation to reach the issue where fundamental fairness is implicated. The situation is directly analogous to the scenario described in Provenzano. Appellant contends that the trial court erred in failing to grant his request for change of venue. However, this issue has not been preserved for appellate review. The trial court granted leave to file an oral motion for change of venue on the first day of trial. The motion was taken under advisement with the condition that a written motion follow shortly thereafter. No written motion was ever filed. This allegation has not been preserved for appellate review because the motion to change venue was neither written, as required by Florida Rule of Criminal Procedure 3.240 and requested by the judge, nor ruled upon by the trial court. We choose to address the substantive aspects of this issue, however, to allay any fear that appellant did not receive a fair trial. Mona, want to go?
They really like that Provenzano guy.
Right?
Just as in Provenzano, the concern here goes to the core constitutional guarantee of an impartial jury. Venue is not a technical or discretionary procedural matter. It's a structural safeguard. See Irvin v. Dowd, and this is 1961. I don't know why I think it's funny when they can't find anything in modern times because they're internet, complaints. When the record demonstrates a credible risk that the defendant was tried before a jury drawn from a community that had already formed a consensus as to his guilt, as it does here, the appellate court may and should consider the merits, even if a procedural rule was imperfectly followed. Unlike other claims that may be forfeited by inaction, the pretrial publicity and venue issues implicate the fundamental right to a fair trial under both the United States and Florida constitutions. When fundamental fairness is at stake, appellate courts routinely review such claims to ensure confidence in the verdict and the judicial process itself. See Holsworth and Provenzano. The court has a duty to review the record in its entirety in reviewing this claim. See Singer v. State, 1959. In determining whether error was committed in the denial of motion for change of venue, we are not limited to consideration of only the motion and traverse and matters submitted in support thereof. We are permitted to consider the whole record and have done so. The record shows pervasive, community-wide prejudice born from nearly a decade of sensationalized local reporting, repeated discussions which tied the case to the identity of the community, and prospective jurors who either acknowledged bias or lied to conceal it, with some openly expressing a belief in guilt in the jury assembly. I hit the bottom of the page. Bottom of the assembly room. This was not sporadic exposure, it was saturation. The state asserts that, quote, the pretrial publicity in Foster v. State, Florida 2000, was more inflammatory than any of the media coverage surrounding Adelson's case. The record does not support that characterization. As an initial matter, the pretrial publicity in Foster occurred in pre-digital media era between 1996 and 1998, when coverage was limited to newspapers and scheduled television broadcasts. Additionally, unlike the defendant in Foster, who was tried around 2 years after the murder, the publicity in appellant Adelson's case spanned 9 years, directly involved the local university community, and repeatedly promoted a narrative of the Adelson family as architects of a long-running plot. Simply put, the publicity in this case is materially different in degree, duration, and depth of local impact than the publicity issue in Foster. The publicity in Appellant Adelson's case was not merely extensive, it was sustained, locally concentrated, narrative driven, and personal. For nearly a decade before trial, the media repeatedly framed the case in terms of community grievance, academic loss, and the moral outrage of a murdered professor at a beloved local university. The coverage did not simply report developments, it amplified the exposure through podcasts, documentaries, social media, commentary, and community forums, effectively intertwining the tragedy with a core civic identity of Leon County. Leon County residents did not simply recall the case, they had lived with it, discussed it, theorized about it, and absorbed it in a shared cultural understanding of a local tragedy. And there's some references to this. I'm not sure what the R is. That is precisely the type of saturation that Irvin, Shepard, McCaskill, Murphy, and Manning identify of such a pervasive nature that it threatens impartiality. Nadine.
Okay. The state also asserts that, quote, if Danny Rolling could receive a fair trial in 1994 Gainesville, then Adelson could receive a fair trial in 2023 Tallahassee. Answer brief at 27. Again, Appellant Adelson respectfully disagrees. The state's reliance on Rolling overlooks the fundamental difference between the pre-digital media landscape of 1994 and the pervasive, self-amplifying media environment of 2023. In other words, the media environment of 1994 is simply not comparable to the media ecosystem of 2023. In Rolling, pretrial publicity occurred almost entirely through traditional news platforms such as local newspapers, nightly broadcasts, and limited national reporting. In 1994, once the newspaper was folded and the television was turned off, the story ended for the day. As such, coverage was episodic and finite. There was no 24-hour social media commentary, no podcasts revisiting the case, no algorithm sending repeated reminders, no discussion threads allowing community members to reinforce one another's views, and no streaming platforms releasing case-related content that are accessible on demand. The publicity ended at the edges of the printed page and the conclusion of the evening broadcast. It did not follow jurors home on their phones, computers, or social media feeds. It did not regenerate or amplify itself and was not algorithmically targeted to continuously reinsert the case into public consciousness. Here, by contrast, at the time of Appellant Adelson's trial, coverage of Dan Markel's murder had been continuous for nearly a decade and had proliferated across digital platforms that did not exist in 1994, including streaming documentaries, podcasts, YouTube, commentary channels, Reddit true crime communities, and numerous social media platforms. Potential jurors reported drawing information from each of these sources and others, demonstrating the extraordinary reach and persistence of the coverage. Potential jurors in 2023 could not simply avoid coverage by not reading the newspaper or watching television. Exposure was persistent, shareable, and algorithmically reinforced, making prejudgment far more likely and far more difficult to screen out than in 1994. The qualitative difference in exposure is profound, and Rolling does not resolve it. The state asserts that the pretrial publicity did not originate either from the police or the state attorney's office. Answer brief at 26 to 27 and 30. Appellant Adelson respectfully disagrees, but more critically, this argument misunderstands the constitutional inquiry. The question is not who lit the fuse, but how completely the fire spread. What matters is the degree of saturation, the tone of the coverage and its effect on the venire. And the effect here was unmistakable. Here, the coverage indisputably favored the state's narrative. Voir dire revealed a community where the presumption of guilt had already been absorbed as common knowledge. 53 of 54 prospective jurors who had formed an opinion believed appellant Adelson was guilty. That is not a neutral starting point. That is a verdict delivered by the community before trial even began. Whether the initial spark came from a press conference by the state attorney or local police, a podcast, documentary, or online commentary is irrelevant. What matters is that the prejudice was deep, widespread, and outcome directing. See McCaskill, 344, blah, blah. Quote, the test for determining a change of venue is whether the general state of mind of the inhabitants of a community is so infected by knowledge of the incident and accompanying prejudice, bias, and preconceived opinions that jurors could not possibly put these matters out of their minds and try the case solely upon the evidence presented in the courtroom, unquote. The state argues that appellant Adelson's use of peremptory challenges somehow undermines the showing of community prejudice, asserting that Adelson's use of peremptory challenges also undermines his argument. Adelson did not use all 9 of his peremptory strikes until the end of jury selection, when he used his leftover peremptory challenges to backstrike 2 prospective jurors. At this point, the state and Adelson had already accepted 12 jurors for the main jury. And there's a citation. If the minds of Leon County residents were truly infected, then Adelson would have run out of peremptory challenges long before 12 jurors were seated. Answer brief at 28. This argument is both unsupported in law and illogical in practice. First, peremptory challenges are not the mechanism for curing a tainted venire. Once a trial court denies a motion to change venue, as explained above, the injury is structural because the defendant is then forced to select a jury from a pool already exposed to prejudicial influence. Moreover, the law does not require a defendant to expend peremptory strikes in a particular order, under a particular strategy, or at a particular pace. Second, the state's premise is factually flawed. The voir dire record shows that more than 4 dozen prospective jurors admitted to having already formed an opinion and believed appellant Adelson was guilty before hearing evidence. The relevant inquiry is the condition of the venire as a whole, not the sequence in which counsel exercised peremptory strikes. Third, the state's assertion misunderstands the role of peremptory challenges entirely. Peremptory challenges are used to remove individual jurors. They do not and cannot remedy the systemic problem of a venire infected, quote unquote, by pervasive pretrial publicity. No number of successful peremptory challenges can cure a fundamentally biased jury pool. Additionally, appellant Adelson exercised all of his peremptory challenges. Despite this, of the 12 jurors who actually sat in judgment of him, 8 had media exposure to the case in some manner. The problem here is not that appellant Adelson failed to remove a particular juror. It is that he was forced to pick a jury from a community where guilt was already the dominant assumption. That is the very harm that a change of venue is designed to prevent. The state claims that, quote, Adelson cannot argue that his trial occurred in a small community, unquote. Answer brief at 27. Appellant Adelson respectfully disagrees. Although the state cites census figures to compare Tallahassee's population to Gainesville's population, next page, community size for venue purposes is not measured by raw population numbers, but by the likelihood that members of the community share exposure to the same news sources and public narrative. See Shepard 384 U.S. at 350, Irvin 366 U.S. at 728, McCaskill 344, blah, blah, blah. More importantly, the characterization of Tallahassee as a, quote, small community, unquote, comes not from appellant Adelson, but from the trial court itself. In granting, quote, defendant Charles Adelson's unopposed motion for protective order, unquote, the trial court expressly found the disclosure of these discovery materials would be big news in this small community, potentially infecting the entire jury pool, even those who at this point may be acceptable jurors. Those without an those without an opinion at this time may form an opinion, thereby reducing the jury pool drastically. Emphasis added. Thus, the trial court recognized precisely what appellant Adelson argues, that Tallahassee is a small community where news regarding this case spreads quickly, is widely discussed, and such news has the capacity to contaminate the entire venire. The state cannot now claim that Tallahassee is too large to raise concerns about community saturation, when it previously relied on the quote-unquote small community nature of Leon County to justify restricting public access to discovery to avoid infecting the jury pool. The trial court's findings regarding Tallahassee as a quote-unquote small community also underscores a key point in the venue analysis. This case was not just known in Tallahassee, it mattered to Tallahassee. That is the defining characteristic of a change of venue motion requiring relocation, regardless of population size. Accordingly, the state's attempt to dismiss the quote-unquote small community concern is both inconsistent with the record and contradictory to its own prior litigation posture, where the prosecutor stated on the record that the state did not oppose appellant Adelson's motion for a protective order because its main concern was to be able to try this case in Tallahassee, and therefore restricting media access to certain discovery was warranted. In short, the trial court recognized the risk. The state did too. The voir dire record confirms that the risk materialized. Mona?
The state did not respond in its answer brief to appellant Adelson's argument regarding the two prospective jurors who misrepresented their impartiality to the court and parties during voir dire, initial brief at 47. The silence is telling. The state's answer brief contains no rebuttal to the following undisputed facts in the record. Page. 1. A prospective juror affirmatively stated that he had no opinion about the case, yet had previously posted on social media that if he were the parent of the victim, he would want to kill co-conspirator Sigfredo Garcia, T2360 to 2364. 2. Another juror represented that he had not formed an opinion regarding appellant's guilt, but was overheard in the jury assembly room stating, quote, he's guilty, in the presence of other potential jurors. These are serious misrepresentations that directly undermine the integrity of the jury selection process. They reflect exactly the scenario that the case law describes, where pretrial publicity is so pervasive that jurors may profess impartiality in the courtroom while holding fixed opinions outside of it. See Patton v. Yount, numbers and reference numbers 1984. Adverse pretrial publicity can create such a presumption of prejudice in a community that the jurors' claims that they can be impartial should not be believed. Emphasis added. This point is particularly significant because it shows that at least two prospective jurors affirmatively concealed their true views when questioned about their impartiality. When jurors misrepresent their opinions in court, the reliability of the entire voir dire process is called into question. If two prospective jurors were willing to deny previously held and expressed beliefs regarding appellant Adelson's guilt, it is entirely reasonable and legally relevant to conclude that other biased jurors may have been seated despite expressing assurances of neutrality. This is the heart of the venue issue. The constitutional harm lies not only in the pretrial publicity, but in the demonstrated inability of voir dire to screen out its effects. The state's decision not to address these jurors in its answer brief underscores this point. If the state believed these incidents were insignificant, it would have said so. Its silence operates as a tacit acknowledgement that these facts powerfully undermine its claim that an impartial jury was selected in Leon County. The record reflects a community atmosphere so infused with belief in appellant Adelson's guilt that some jurors felt compelled to conceal their prejudgment in order to serve. As the United States Supreme Court has recognized, our system of law has always endeavored to prevent even the probability of unfairness. Shepard, U.S. 352, quoting the language of Justice Black for the court in R.E. Murchison from 1955. With his life at stake, it is not requiring too much that petitioner be tried in an atmosphere undisturbed by so huge a wave of public passion and a jury other than one in which 2/3 of the members admit, before hearing any testimony, to possessing a belief in his guilt, unquote. Irvin, California, 1952, Shepard v. Florida, U.S. 1951 concurring opinion, and Moore v. Dempsey, 261 U.S. 86 from 1923. These principles apply in full force here. The law strives to avoid even the probability of unfairness, and a trial cannot be fair when the community has already reached a verdict before a single piece of evidence is presented. The threat to fairness becomes even greater where prospective jurors conceal their preformed beliefs during voir dire. In such circumstances as here, a change of venue was necessary to protect appellant Adelson's constitutional rights. Accordingly, a new trial is required. We made it through one.
Thank you.
Yeah.
Any
Can I-
comments?
Can I
Judy,
point
about-
out one thing? I kind of want us to get through this, but the first potential juror that they're complaining about, he said he didn't have an opinion on the case, but probably meant that he or she didn't have an opinion as to Charlie's guilt.
Right.
So whether he had previously said if he were Dan's parents, he would have wanted to kill Sigfredo, it doesn't mean he can't be impartial in Charlie's trial. That's my opinion.
Exactly.
So that's
And
not a
they were
good
it's
example.
very redundant. They kept just saying the same words.
It just sounds like they are trying to rehash. It's like the judge denied it already, but they're trying it now with the appellate court, right? Because they're basically making the same arguments that they made in their motion for change
Right.
of venue.
For a new trial with right there. The
Mhm.
other issue is that they're insulting other jurors by saying the claims of these two jurors, they're saying all the rest of the jurors are lying. That's
Yeah,
what I got out of
they're
that.
all
They just wanted to
tainted.
be on the jury.
And the next point is I live in California and I think they're all guilty for years before they're tried. So where are you not gonna see that? Why
Yeah,
would a different area make it any better or worse?
yeah,
Right?
exactly. Especially now that there's social media and people who are obsessed with the case. Well, people obsessed with the case wouldn't have been chosen anyway.
And I think that people, I would like to know, Judy, you were at Charlie's trial.
Yeah.
Were there a lot of younger people on the jury?
Uh, in that jury, no, not really. They
Okay,
definitely had more younger people in Donna's trial.
Donna's trial. Because I was
Yeah.
going to say, I would love to know how
Well,
many of the
wait a second.
jurors
I'm
probably weren't
sorry.
even in Tallahassee when this murder happened. Like, you know what I mean? Because people move in and out. And I just wonder about that with Charlie's jury. Like they're making all these rubbish arguments that, oh, it was so pervasive, like, like it's the OJ trial or something. It wasn't that
Mhm.
pervasive for the whole number of years between when the murder happened and Charlie's trial.
I
Yeah.
agree. It's just because we waited 18 months for that trial
Right.
doesn't mean
Right.
I was
Everybody in Tallahassee was not
like,
paying
Yeah. Most
attention to
people
that.
have
and
real
and
lives that
think
distract them
about the
from this.
think about the people that you know that could care less about the trials that you're interested in.
Yep.
They don't read
Exactly.
about it. They don't care about it. That's not what their YouTube says. That's not what they look on Reddit. It's just, it's almost
There
conceded to.
Yeah, and cases are happening right now, I'm sure, in Fort Lauderdale, Miami, that I'm not paying attention to. And
Hmm.
they might be on the news. And, if I get pulled for the jury, like, yeah, I don't know anything about this.
Hmm.
So I think there are a lot of people who probably were on his jury who didn't know anything about it.
Yeah, exactly. I mean, ultimately, they did find people who weren't tainted. So
Exactly.
it's kind of weird to go back in time and say, no, they were so saturated because the whole town was saturated
And
with,
It's
with
doesn't
movie.
a appellate argument have to do with basically making legal errors, like serious? Isn't that how it goes, Judy?
Yeah, but Judge Everett did deny the motion to change venue.
But his
So that's
reason, he had reasons, and he said his reasons.
yeah, but of course Charlie had the right to say, you know, to be
that it was a wrong decision.
Monday
Yeah.
morning quarterbacking. Yeah, because wasn't Charlie like just totally bragging about the jury consultant
Oh,
and
yeah.
Dan Rashbaum did a great job and he wasn't complaining about his jury right after his verdict. So,
No.
well, he did say they were like inbred, three inbred white men, those black people.
But he wasn't complaining about it throughout the trial. It was when
Yeah,
he got convicted,
it
then
was
all of a
after it.
sudden, I knew it.
I know he
Yeah,
really thought he was going to be exonerated like Donna
He
did.
was
It's
going
like,
home.
but
yeah.
he stood there with his hands in his pocket, standing up, agreeing to that jury, if I recall correctly.
Yes.
Hmm.
It's a rubbish argument, number one. And they know it because, it's not going anywhere.
Well, a couple of sentences were pretty good, and it just reminded me that I'm glad I'm not in college or high school where I have to write reports like that, where you have to fill in the amount of words and
And citations.
yeah, all right. Didn't it
Okay.
remind you of like college work?
Yeah.
Yes, definitely. Yeah. Okay, so where were we?
Number
Number two?
two,
Okay, whose turn is it to
I
read?
guess it's my turn. So
Okay,
number two,
thank you.
the trial court erred by denying appellant Adelson's motion to strike the venire panel after several potential jurors reported to the court and the parties that other potential jurors were having conversations about the case after being instructed not to do so. You gone too far? Can you come down a little? Yeah. As to claim two, appellant Adelson continues to rely on the argument in the initial brief. The record reflects multiple independent reports that prospective jurors were discussing appellant Adelson's case, including expressions of guilt, after being specifically instructed not to do so. Under these circumstances, the trial court's refusal to strike the venire panel was an abuse of discretion. Really? The state's argument that appellant Adelson's quote affirmatively accepted, appellant Adelson quote unquote affirmatively accepted his jury without objection, answer brief at 31, ignores the multiple contemporaneous motions and renewals of the motion to strike the venire throughout voir dire. Defense counsel moved repeatedly to strike the panel as more reports of improper discussions and premature judgments emerged. I just have to say this. You notice they are not naming names. Even in number one, when they're saying, oh, it was so saturated that they can't say, well, this person was biased and this person shouldn't have been on the jury because of this. It's all just generalities.
Well, and they're talking about prospective jurors. Those people weren't even selected.
Yeah. And the ones who said they thought he was guilty, 59 out of 60 said they thought he was guilty. Okay, but how many did you see? 300, right?
Yeah, out of three. Yeah. The 60 of the 300.
Yeah.
Right.
So
or 500 or whatever it was.
Yeah, very self-serving focus on that. This is not a case where a single early objection was abandoned. Rather, the defense renewed its objection multiple times, each time prompted by newly revealed misconduct within the panel. By who? There's misconduct, but by who? The record plainly reflects an ongoing, preserved objection that a particular section of the venire was tainted. The state's reliance on Johnson v. State and Hayes v. State is unpersuasive. In those cases, the defendants failed to renew or maintain their objections after voir dire concluded, leaving open the possibility that the objections had been abandoned. Here, by contrast, defense counsel objected and renewed the motion multiple times during voir dire while the prejudice was unfolding, and the trial court expressly ruled on each one. There was nothing further to renew after the court denied the motions and proceeded to trial. See also Caratelli v. State from 2007. Under our cases, the preservation of a challenge to a potential juror requires more than one objection. Here, defense counsel did make more than one objection/motion, and therefore the motion was renewed before the jury was sworn, i.e., multiple times during voir dire. Appellant Adelson also notes that the circumstance in this case does not pertain to the preservation of a challenge to one specific potential juror, but to an entire section of jurors who were exposed to impermissible content or committed misconduct themselves. Relatedly, the state's procedural argument under Florida Rule of Criminal Procedure 3.290 also fails. The state argues that Appellant Adelson's, quote, oral motion was legally insufficient, unquote, quote, because Adelson failed to comply with Rule 3.290, unquote. Answer brief at 32. Rule 3.290 states, the state or defendant may challenge the panel. A challenge to the panel may be made only on the grounds that the prospective jurors were not selected or drawn according to law. Challenges to the panel shall be made and decided before any individual juror is examined, unless otherwise ordered by the court. A challenge to the panel shall be in writing and shall specify the facts constituting the ground of the challenge. Challenges to the panel shall be tried by the court. Upon the trial of a challenge to the panel, the witnesses may be examined on oath by the court and may be so examined by either party. If the challenge to the panel is sustained, the court shall discharge the panel. If the challenge is not sustained, the individual jurors shall be called. Emphasis added. Plainly, Appellant Adelson did not assert a, quote, challenge to the panel, unquote, as contemplated by the rule. The purpose of the rule is to address irregularities in the formation of the jury panel itself, such as the systematic exclusion of a class of persons based on race, sex, ethnicity, religion, or similar characteristics. See generally Gordon v. State, Florida, 1997, quote, while defendants are not entitled to a particular jury composition, jury wheels, pools of names, panels, or venires from which juries are drawn must not systematically exclude distinctive groups in the community and thereby fail to be reasonably representative thereof, unquote. Citation omitted. Simmons v. State, Florida, 1966, quote, "It is crystal clear that in making up the jury list, there was an intentional and systematic exclusion of common laborers as a class. By contrast, the appellant Adelson's motion sought to strike a portion of the venire, specifically jurors 51 through 102, not because of any illegality in the panel's formation, but because those jurors either 1, violated the court's directive not to discuss the case, or 2, were exposed to comments from other prospective jurors who violated the court's directive not to discuss the case. It was not possible to make the motion to strike the panel or rule upon it, quote, before any individual juror is examined, unquote, because it was the voir dire examinations themselves that revealed the misconduct. Accordingly, Rule 3.290 was not implicated, and appellant Adelson was not required to submit the motion in writing to preserve the issue for appellate review. Additionally, the grounds for the motion stated by trial counsel were factually specific and made on the record, which ensured that the trial court and opposing counsel were aware of the factual basis for the challenge. The trial court and state both responded to the substance of the motion, leaving no doubt it is properly before the court. See Steinhorst v. State, Florida, 1982. Quote, "In order for an argument to be cognizable on appeal, it must be the specific contention asserted as legal ground for the objection, exception, or motion below," unquote. Accordingly, this court may review the issue on appeal. See State v. Calvert, Florida, 2009. Quote, "The purpose of the contemporaneous objection rule is to place the trial judge on notice that error may have been committed and provides him an opportunity to correct it at an early stage of the proceedings. Objections may be preserved on the basis that their purpose is clear from the context," unquote. Citation omitted. The trial court abused its discretion when it refused to strike the panel of tainted jurors. The issue was preserved, as explained above, and thus the correct standard is abuse of discretion. Nonetheless, appellant Adelson contends that the error amounts to fundamental error, because it cannot be said that the guilty verdict could have been obtained without the error. See FB versus State, Florida, 2003. Quote, "The sole exception to the contemporaneous objection rule applies where the error is fundamental." In other words, even if this court were to apply fundamental error review, the result is the same. An error is deemed fundamental, quote, "when it goes to the foundation of the case or the merits of the cause of action and is equivalent to a denial of due process," unquote. JB v. State, Florida, 1998, citing State v. Johnson, Florida, 1993. "The pervasive nature of the improper discussions here meets that standard. The state minimizes what occurred by labeling the misconduct as, quote, isolated comments," unquote, answer brief at 33. The record tells a different story. Jurors repeatedly reported that other potential jurors were openly discussing the case, sharing details, and expressing opinions of guilt despite explicit court instructions not to do so. At least 3 distinct prospective jurors confirmed these violations, each describing different speakers, conversations, and opinions. One juror stated that people were discussing the case, quote unquote, all day. Another heard someone say, quote, "I think he did it," unquote. This was not a single rogue remark. It was a pattern of disobedience and premature deliberation across multiple potential jurors. In response, the trial court reiterated its admonition to the panel and removed a few identified jurors for cause. But, as defense counsel correctly observed, this did not cure the problem. Quote, "We have no idea who this young man said this within earshot of," unquote, or how many others were affected. In short, nothing in this record supports the state's assertion that appellant Adelson received a fair trial from well-mannered, untainted jurors. Answer brief at 35. When misconduct permeates the venire to this degree, the court's admonition could not restore the presumption of impartiality that the Sixth Amendment requires. Mona?
Given repeated reports of improper juror discussions and admissions of guilt opinions, the trial court's decision to proceed with the tainted veneer was unresponsible. The court recognized the problem, warned the panel, and removed some jurors, but declined to address the broader contamination. That half measure failed to safeguard Appellant Adelson's constitutional right to an impartial jury. Allowing a tainted jury panel to remain intact violated Appellant Adelson's constitutional right to a fair and impartial jury and deprived him of his right to a fair trial. See U.S. Constitution Amends v. 14. Constitutional appellants' convictions must be reversed and remanded for a new trial before an untainted jury.
We got to number 3.
But I think this is all part of the same one issue now that we got through 2.
Yeah, the same jury.
They're accusing vague jurors of misconduct that weren't actually chosen, and then they're honing in with lots of case law to make it look fancy, and they probably charge by the word or the page or something.
It's just blah, blah, blah. It's like there's nothing for the appellate court to grant them relief with.
They're spending some of that good cash, so
yeah.
I don't know. I mean, I'm obviously not an attorney, but Judy is. Any thoughts?
Well, I mean, they have to come up with some arguments, but it just seems kind of silly because, as we've stated, they still found people to sit on the jury. So these complaints are just kind of like vague, generalized complaints because of prospective jurors who were clearly removed. They didn't sit on the jury.
Potential. Oh, they said this to a bunch of potential jurors.
Or we don't know if those other people heard them. Yeah, well, we don't know.
Or they're also assuming that people have no opinions or aren't thinking, well, that's rude. We're not, he shouldn't have any opinion. Or they're just saying, I believe the person that was kicked out because I don't have a mind of my own.
Right.
If they heard anything. Yeah. So that's a lot of assumptions. Anyway, number 3, that probably has to do with this unfair jury trial based on the vague, unchosen jurors. Number 3, the trial court erred by excluding defense proffered defense proffered text messages that would have shown Appellant Adelson and other alleged co-conspirators communicating, quote, normally, unquote, during the time leading up to Dan Markel's murder to rebut the state's contention that Appellant Adelson and alleged co-conspirators were making phone calls about the murder during the relevant time period. As to Claim 3, Appellant Adelson relies on the argument outlined in his initial brief. The state responds that none of the text messages Adelson sought to introduce into evidence contained any relevant information. Also, some of Adelson's texts contained sexual, racist, and misogynistic references that would have embarrassed Adelson had they been admitted. In any event, Adelson suffered no harm because he testified about the content of his text messages. Answer brief at 36. Appellant Adelson respectfully disagrees with each of these points. The state's claim that Appellant Adelson, quote unquote, invited the error because he did not proffer, quote unquote, individual text messages mischaracterizes both the record and the nature of the trial court's ruling. The record reflects that the defense counsel sought to introduce the messages collectively as a single exhibit offered not for the truth of the matters asserted, but to rebut the state's multiple inferences that phone communications between Appellant Adelson and others around the time of the murder related to the murder itself. T 1589 to 15, I guess that's the transcript, 1593, reference 2015 to 2065. Because the state presented its phone call evidence as a pattern or composite rather than individually, the defense needed to enter the text messages in the same collective format to provide a meaningful rebuttal. Counsel expressly articulated the relevance of the messages, which was to demonstrate that Appellate Adelson and the alleged co-conspirators were communicating, quote unquote, normally about work and daily life rather than criminal activity. Transcript 1591 to 1593. That the trial court suggested to the defense that it could, instead of offering the composite exhibit, enter specific messages, and that the defense counsel ultimately declined to do so, did not, quote unquote, invite the error as suggested by the state. Answer brief at 36. Quote unquote, invited error occurs when a party induces the trial court into error or affirmatively agrees to the challenged ruling. See White v. State, 446, Florida, 1984, holding that the defendant cannot take advantage of an appeal of the situation he created at trial, citing McRae v. State, Florida, 1980. The trial court's statement that if there are portions, again, that are specifically relevant to negating either the motive or any of the elements of the charges and are not hearsay as argued by the defense, I will consider those separately. But as a composite on the whole, the 403 issues, the relevance and hearsay issues, I believe compel me to deny their admission. Transcript 1593 did not transform the exclusion into an invited error. Once the trial court concluded the composite on hearsay, relevance, and prejudice grounds, further individual offers would have been futile. Simply put, invited error occurs when a party induces or acquiesces to a ruling they later contest, which is not the situation here. The purpose of introducing the composite exhibit of text messages was to show the pattern of ordinary, non-criminal communication between Appellant Adelson and the alleged co-conspirators during the critical time period surrounding Dan Markel's murder. The exhibit was not offered to prove the truth of any statements, but rather to demonstrate that, contrary to the state's suggestion, the communications consisted of routine discussions about work, family, and personal matters, and did not indicate planning, coordination, or awareness of the murder of Dan Markel. That alone, that alone established the relevance of the evidence. It directly rebutted the state's inference that phone communications during the same time frame were conspiratorial or connected to the murder. Evidence that tends to disprove an essential element of the state's theory or that creates a reasonable doubt regarding participation in a crime is squarely within the scope of relevant evidence. See something Florida statute. In response to the state's assertion that the evidence lacked relevance, Appellate Adelson turns to the well-reasoned decision of the Second District Court of Appeals in Mateo v. State 932, Florida, 2006. There, the Second District explained Florida law is clear that, quote, where evidence tends in any way, even indirectly, to establish a reasonable doubt of defendant's guilt, it is error to deny its admission, unquote. Rivera v. State, 561, Florida, 1990. This principle is based in part on the U.S. Supreme Court's holding that few rights were more fundamental than that of an accused to present witnesses in his own defense, Chambers v. Mississippi, 1973. Thus, as a general proposition, any evidence that tends to support the defendant's theory of a defense is admissible, and it is error to exclude it. Dean v. State, 2005, Venire v. State, 1998. Further, quote, while the defense is bound by the same rules of evidence as the state, the question of what is relevant to show a reasonable doubt that may present different considerations than the question of what is relevant to show the commission of the crime itself, unquote. Whatever that was a lot of word salad to me. Venire at 2D at 472. Thus, in Venire, the court held that it was error for the trial court to have excluded evidence of letters written by the victim that tended to show she was depressed and thus arguably supported the defendant's theory that the victim was not murdered but instead committed suicide. Similarly, in Bertram v. State, Florida, 1994, this court held that it was error for the trial court to refuse to permit the defendant to cross-examine a witness as to prior altercations between the defendant and his father when the theory of the defense was that the father had, quote, set up, unquote, the defendant in retaliation for the altercations. Likewise, in Dean, the court held that it was an error for the trial court to refuse to permit the defendant to introduce a pawn slip when the defense theory was that the person who pawned the jewelry rather than defendant was the perpetrator of the robbery. In this case, Mateo's theory of defense was that the jail officials were biased against him because he had been vocal about jail conditions in the past, and they made up their story about the lunch tray and the shank to cover up their misconduct. The audio tape in question, my eyes just lost it. Where am I? The audio, I see it. The audio tape in question does provide some evidence that supports this theory. The jail employee indicated that Mateo was placed in lockdown based solely on his, quote, past behavior, unquote, and that she would be moving Mateo to a different facility so that quote, the supervisor won't go after him, unquote. These statements made by an employee of the jail where the incident occurred provide at least some evidence of a pre-existing animosity between Mateo and the jail officials. This animosity, in turn, could provide evidence of a bias against Mateo by the jail officials that might affect the jury's assessment of their credibility and/or their recollections and interpretations of the events supporting the charges. Thus, the audio tape was relevant that it tended to support Mateo's defense and that the trial court erred in excluding it from evidence. Ooh, okay, Nadine. I'm like, that didn't make, I didn't get the argument.
I don't think it makes any sense.
Okay.
They're making the appellate court have to, make sense out of nonsense, basically.
Right, but to just detail all they already cited it. What's the purpose of detailing a case they're citing that isn't the same thing? And they're vague, it's vague kind of comparisons.
To show text messages, that just show them talking about everyday things, not the crime, means it's irrelevant. This is what makes the crime talk stand out.
Are they inferring that Charlie upset the judge and that the court was unfair to him because of other behavior? That argument?
No,
I don't know if I'm getting that.
Yeah, I get the feeling that they want to show that, look, they weren't talking about murdering Dan in these text messages. Therefore, he didn't murder Dan.
Right.
Because they're just talking about normal family stuff.
And when they talk code talk, that means nothing because, see, yesterday they were talking about normal everyday stuff.
Yeah, so they just happen to always call each other right around the time or text
The
right
cars are
around the
being
time that
rented, and
that
yeah.
hitmen are coming to drive and follow Dan Markel, you know.
Yeah.
Yeah. So
That
um
was a lot.
that's a lot of reading. So actually it's not total 66 pages of reading because there's a big chunk that was towards the beginning.
We
And
Okay.
can do it.
yeah,
We
you
can
can
do
do
it,
it. Thank you
Judy.
guys. Thank you guys for being here. I'm getting sleepy already. I don't know how you guys feel. But
Well,
Well,
let's make
do
it
you want to
through.
skip ahead or
no,
something?
no, no. I
No?
mean, if
Okay.
you're okay with reading, then
Yeah,
please
sure.
do, because I think people are so into it that I do want to hear it. I'm just
Okay.
saying in general, I'm sleepy. So, but thank you.
Applying the principles explained in Mateo, the trial court in this case similarly erred in excluding evidence that appellant Adelson regularly communicated with the alleged co-conspirators and that they were communicating quote unquote normally about work and daily life rather than conspiring to commit the murder during the time leading up to the murder. Just as the excluded evidence in Mateo tended to show bias and animosity that could support the defendant's theory of defense, the evidence of appellant Adelson's quote unquote normal communications was directly relevant to appellant Adelson's theory that he did not conspire with others to commit the crime, but was later blackmailed into paying money to Catherine Magbanua, who in turn paid the killers. Critically, quote unquote, some evidence supporting the theory of defense is sufficient to warrant admission. Mateo 932, blah, blah, blah. Here, even, next, here, even during the relevant time, no, where am I? Yeah,
Here,
here, even modest evidence that appellant Adelson communicated quote unquote normally during the relevant time period was enough to support the defense's claim that appellant Adelson was one, not involved in soliciting Magbanua, Rivera, or Garcia to commit the murder, and two, conspiring with Magbanua to commit the murder, or three, guilty as a principal to the murder itself. By presenting the jury with the substance of the messages, the defense sought to show a lack of pattern of criminal intent and to illuminate appellant Adelson's state of mind. In urging the trial court to admit the exhibit, defense counsel articulated the relevance of the messages to appellant Adelson's state of mind. His state of mind is not that he's gonna commit a murder. His state of mind is his normal, everyday activity. My life is the same as it was in February. I'm not talking about a murder. I'm not worried about anything. I'm living my life. That's what these text messages show. The state also contends that the exclusion of the messages did not prejudice appellant Adelson. Answer brief at 43 to 44. Respectfully, appellant Adelson submits otherwise. By barring the defense from presenting this evidence, the trial court deprived appellant Adelson of the opportunity to fully present his defense and to challenge the prosecution's narrative that he and Magbanua were communicating about the murder. Like the evidence in Mateo, this information was not peripheral. It was central to the jury's assessment of reasonable doubt and to appellant Adelson's constitutionally protected right to present a complete defense. Accordingly, the trial court's ruling constitutes reversible error. The state argues that the composite text message exhibit, quote, contained sexual, racist, and misogynistic references that would have embarrassed Adelson had they been admitted, unquote. Answer brief at 36. Further, the state argues that, quote, the texts would have likely angered the jury, unquote. Answer brief at 44. But this misses the point. Appellant Adelson deliberately sought the admission of the exhibit, fully aware that some messages contained offensive language. He understood the potential for embarrassment, yet chose to try to introduce the messages because their probative value, showing normal, everyday Oh, there's a large footnote.
Yeah, can you read the footnote too, please?
Go back up. Where's it?
Sorry.
Where's the
Okay,
footnote? Number 5. Right there where he said, no. Down. It says right there, fully aware that some messages contained offensive language, then the footnote. During the trial, the following was said. The court. The other concern I have with this, as it would possibly cast even your client in a bad light, quote, it was good seeing you, Negro, unquote. I think he called Ms. Magbanawa at one point a strong black woman.
What the? That's weird. What is wrong with these people?
Boy, I'm glad it wasn't my turn.
It was good seeing you, Negro. Like, who is he talking to?
These people are crazy.
I think he called Ms. Magbano at one point a strong black woman. I don't know if there's any references to the N-word or other things in here. There were with the other witness. But this is going to be a look at your own risk. Mr. Rashbaum, I understand, Your Honor. The court. Please review to find the most relevant nuggets that go to actual state of mind. Mr. Rashbaum, okay, they all go to state of mind. I can't believe he was fighting to get such text messages into evidence. Really?
Yeah, it looked kind of weird.
That was not going to be good for your client, Rashbaum.
Judge Everett denied something similar in Donna's trial to not.
Yeah, some kind of racial, and that one wasn't even that bad. She said something about the judge being a Southern black woman or something.
Yeah.
But this, and I know that in Katie McManus' trial, not to get off track, but there were some text, maybe it was at Charlie's, where Katie was saying to him, like, you're my N-word for life, you know?
Yeah.
So they talk like that too, because I even was taken aback by that, like, okay, none of you are black. Like, what are you talking?
Yeah, they think they're super cool or something.
They just think they're cool. Like,
they're gangsta.
Yeah, Charlie the gangster periodontist.
Yeah, that's what you call appropriation, really. Because it's like, neither one of you have any business talking like that.
Him in the van going, my man.
Right?
Yeah.
So cool. Okay.
So getting back to, showing normal, everyday, what's next? Okay.
And then I read that part. Communications and rebutting the state's inference of criminal intent far outweighed the risk of discomfort or prejudice to himself. In other words, Appellant Adelson made a strategic decision to prioritize his constitutional right to present a defense over the concern about personal embarrassment. That some of the text messages may have contained language or content that could have embarrassed Appellant Adelson does not make their exclusion proper. Appellant Adelson's willingness to risk personal embarrassment in order to present relevant exculpatory evidence underscores, not undermines, the legitimacy of his position. Footnote 6. As an aside, by way of connection back to the doctrine of invited error, Appellant Adelson notes that had the exhibit been admitted and Appellant Adelson later complained on appeal that the messages embarrassed or prejudiced him because they contained sexual, racist, or other offensive references, that argument would have amounted to invited error.
It would. They would have used it. If they used it, then he would say that's why.
Exactly, because it prejudiced the jury against him. The trial court excluded evidence that Appellant Adelson affirmatively wanted the jury to see to support his defense. The trial court's exclusion of the text messages violated both the evidence code and Appellant Adelson's constitutional right to present a defense. The proffered texts were relevant to rebut the state's inference that communications between Appellant Adelson, Magbanawa, and members of his family concerned the murder. See statute, Florida, blah, blah. Evidence is relevant if it tends to prove or disprove a material fact. The error undermines the confidence in the outcome of the trial and goes to the very foundation of the case. See Everett v. State. Florida DCA, first DCA 2013. The state's assertion that, quote, the jury would have been unsurprised to learn that Adelson did not text about the plot to kill Markel, unquote, also misses the evidentiary point. Answer brief at 47. The jury's hypothetical lack of surprise, quote unquote, at the absence of incriminating statements cannot render otherwise relevant and exculpatory evidence inadmissible. See this Florida statute. Moreover, the state cannot both imply that appellant Adelson's communications, the chain of traffic of phone calls, supported its theory of guilt and then argue that the actual content of communications between the same people is immaterial. Footnote 7, defense counsel identified this inconsistency. Mr. Rashbaum, just for the record, in the state's case in chief, they were allowed to put in phone calls showing the arrows indicating that they have no idea anything said on those calls. That they have no idea anything said on those calls. Yeah, that's what it says. It doesn't make any sense though. What? They have no idea of what was said on the calls?
Appellate?
I don't know.
Yeah, he's saying, because I understand Rashbaumese, he's saying that when they have an arrow up on their
presentation
parts, that they're saying this person talked to that person and that person, but they can't know because they don't know what was said on some of the calls.
Right.
That they didn't have the words for. That's what I think.
They have no idea what about anything said on those calls. They're essentially the same thing as putting in text messages like this, except you actually see the content, right? The court, the chain of the traffic versus what is actually said. Mr. Rashbaum, they put in every call, okay? They put in every call between these participants on those particular dates, which, by the way, correspond mostly to the days that I'm offering these text messages for. They put them in for their own purposes. I think I should be allowed under 403 analysis, what's good for the goose is good for the gander, to put in the text messages to show the pattern or lack of pattern of anything. And that's what these text messages show. But I can just ask the questions. But I would like the record to reflect that under a 403 analysis, it was allowed for them. It's not being allowed for us. The court, I wouldn't exactly say it boils down to being that simple, but your objection is noted, specifically as to what the state was permitted to demonstrate in their case in chief goes to either demonstrating motive or direct evidence of what they believe show the elements of the charges. As to these composite exhibits, and again, I don't want to get very deep into what the subject matter is, there are messages that either go to embarrassing of the other witnesses or litigants in this matter, matters that are wholly irrelevant or matters that do not demonstrate in any way the theory of defense as the court understands it. If there are portions, again, that are specifically relevant to negating either the motive or any of the existence and timing of those communications, fairness required that the defense be permitted to introduce the content to place the inferences in their proper context. Excluding the messages deprived the jury of the best and most direct evidence of what those communications truly were, i.e., ordinary, not conspiratorial. Finally, the state asserts that appellant Adelson was not harmed by the exclusion of his proffered evidence because he testified about the text messages. Answer brief at 43 to 44. Respectfully, appellant Adelson does not share the state's view. A defendant's own testimony is no substitute for contemporaneous documentary evidence that objectively corroborates the theory of defense. Jurors could reasonably view a defendant's testimony as inherently self-interested, whereas the text messages themselves would have provided independent. Is this like
Sorry,
a footnote
like,
continuing?
Yeah, that's more of the same footnote from the previous page. So
yeah, it was
Ellen,
like half of the other one. It's weirdly positioned.
Yeah.
So then the text will be below that, I think.
Okay.
So
Yeah,
they
it's
continue the
confusing.
footnote.
Yeah.
Right, in
Okay.
between. So the footnote is always single spaced, and then
Yeah.
the text is double spaced, and then it went back to a smush
So we're
of,
now back into what the judge was saying. Elements
Uh,
of the charges and are not hearsay, as
yeah.
argued by the defense. I will consider those separately, but as a composite on the whole, the 403 issues, the relevance and hearsay issues, I believe compel me to deny their admission. Mr. Rashbaum, thank you, Your Honor.
Okay. So then we get back to the actual text
Right.
of the brief. Okay.
So
Okay.
contemporaneous proof of his state of mind and shown the ordinary non-criminal nature of his communications to rebut the state's claims that appellant Adelson was planning a murder with the people with whom he communicated. Further, appellant Adelson's testimony was only a fraction of the evidence necessary to support the defense theory. The trial court's exclusion of the text messages, which would have provided some evidence that he regularly communicated with the so-called co-conspirators not about murder, effectively left appellant Adelson with no meaningful evidence to present to the jury in support of his defense. See Mateo, blah, blah, blah. Such a decision is generally considered harmful error. See Zanichi v. State, from Florida, 4th DCA 1996, finding exclusion of the defendant's only proffered evidence in support of his defense to be harmful error. The exclusion of the text message evidence violated appellant Adelson's fundamental right to present a complete defense and left the jury with an incomplete and misleading picture of the interactions at the heart of the case. The resulting prejudice was substantial. On one hand, the state was permitted to introduce a pattern of phone calls and argue to the jury that they reflected communications related to, so footnote 8. Significantly, the state emphasized this argument in its closing. Ms. Kappelman, the communication records tell us a few other things too. That's the June trip. July, June. This slide shows all the calls between our parties on the night before the shooters made that June trip to Tallahassee. You can see a 25-minute call from Catherine McBanoa to the defendant at 9:17 p.m. on June 2nd, 2014. This call was placed while Catherine McBanoa was, consistent with traveling on her way back from Comfort Rental Car, where the first rental car was rented, to her residence. As soon as the defendant hangs up with Katie, he calls his parents' landline and has a 25-minute conversation. On the day of the murder, we have communications between our parties as listed here, with the red line representing time of the murder. This flurry of calls between our persons of interest demonstrates the usual call pattern that we're seeing. Donna to the defendant, to Catherine McBanoa, to Garcia, and back. So we've got all this evidence that points to the defendant. The motive points to him. When we follow the money, it leads to him. The Prius eventually leads back to him through these conspirators. And each time we have a big event in this case, we see these call flurries where all the parties are calling each other in that structure that I talked about. It goes from this one to this one to this one. But as the defense points out, these folks had independent relationships with each other that could explain those communication patterns. So without knowing the content, how could we know if they're really talking about the murder or if these call flurries around these key events are just a coincidence? A conspiracy can be shaped like a cluster, with everybody talking to everybody. It can be shaped like a wheel, with one central hub talking to all the different spokes. Or it can be shaped like a train car, which is what we have here, where one person talks to only the person, the car in front of them, and the car behind them.
just like they did in Donna's trial, only they got better with the tech.
Hmm. That might be the end of that footnote. I don't know.
Yeah, then it goes back to the single. They reflected related to and then
Okay.
you have to go find
Yeah,
the.
these footnotes are so
Weird.
aggravating. I hate these
Well,
footnotes.
they're oddly placed.
Yeah, because he can't finish it in one page, so then you have to turn to the next page to keep reading the
The
footnote,
footnote.
then go back
Really
to
figured
read the
out on
body.
page 59 or something.
Okay,
So they
so
reflected communications related
And
related
then
to
skip the.
skip
We
the
already.
murder.
the murder. On the other hand, appellant Adelson was precluded from rebutting that claim with direct evidence that would have done so. The error was not harmless. Florida appellate courts have consistently held that an error is not harmless when the evidence that is the subject of the error is highlighted or emphasized by the state during closing arguments. See Martinez v. State, Florida 2000. Quote, we cannot find the improper opinion of guilt testimony to be harmless beyond a reasonable doubt, especially when it was again highlighted in closing argument, unquote. Allen v. State, Florida 4th DCA 2016, quote, the fact that the state emphasized this erroneously admitted evidence in its closing argument also may have tainted the validity of the jury's verdict, unquote. The improper exclusion of the text messages resulted in a violation of appellant Adelson's constitutional right to a fair trial. See U.S. Constitution Amendment, blah, blah, blah. And
Do we need to go
constitutional,
back to their little footnote on top of that?
I think we read it.
Is that?
The card,
Yeah,
talking about
we've read it.
the conspiracy.
Oh, okay.
Yeah.
Mhm.
Phew.
We
Good job.
read that.
Thank you.
We got to number 4.
Yay. Okay. Great job. We're getting through it. Almost done. What? Probably 10 more actual pages.
I do
Yeah.
not think that argument holds any water either, because there were a lot of text messages that showed them just talking about random things.
Well,
Yeah.
they just make all these assumptions when they're saying this is fact, and it's just their opinion. It's oddly written.
And then they quote these citations that clearly are not, they're like false equivalents. You can just tell.
Yeah,
Yeah.
it's amazing. But I guess what are we? Okay, so number 4, the trial court erred when it excluded evidence that was highly probative to the theory of defense, which was relevant and both non-hearsay and accepted from the hearsay rule, i.e., a recorded phone call from 2016 in which appellate Adelson references a past extortion. As to claim 4, appellate Adelson continues to rely on the argument made in the initial brief. In its answer brief, the state argues that the excluded evidence was hearsay, not subject to a hearsay exception, and the exclusion did not prejudice appellate Adelson. For the reasons we set forth below, appellate Adelson respectfully disagrees. He's so respectful in this. The state's argument regarding hearsay rests on the mistaken premise that appellate Adelson offered his statement, the phone call, and specifically the quote, it's not done like that, unquote, for the truth of the matter asserted. The record demonstrates otherwise. The defense did not seek admission of the recorded phone call to prove that extortion generally occurs in a particular manner. Rather, the statement was offered to show appellate Adelson's contemporaneous belief and state of mind, specifically that the people confronting his mother were not the same individuals who had previously extorted him following Dan Markel's murder. This belief directly supported the defense theory that appellate Adelson was a prior victim of extortion related to the murder and not a participant in a conspiracy to carry it out. Number 3, this statute provides then existing mental, emotional, or physical condition. A statement that the declarant's then existing state of mind, emotional, or physical sensation, including a statement of intent, plan, motive, design, mental feeling, pain, or bodily health, when such evidence is offered. 2, Number one, prove the declarant's state of mind, emotion, or physical sensation in that time or at any other time when such state is an issue in the action. Number two, prove or explain acts of subsequent conduct of the declarant. B, however, this subsection does not make admissible one, an after the fact statement of memory or belief to prove the fact remembered or believed, such as statement relates to the execution, revocation, identification, or terms of the declarant's will. Two, a statement made under circumstances that indicate its lack of trustworthiness. As such, according to this Florida statute, the offered evidence was an out-of-court statement offered to show appellant Adelson's beliefs, impressions, and/or reactions, and it is captured by Section 90.803 as a hearsay exception. Additionally, because the statement was not offered for truth of the matter as it asserted, it was not hearsay or non-hearsay. See Field v. State, Florida, 1992. Utterances which circumstantially indicate a specific state of mind causing them do not constitute hearsay. Emphasis added, citation omitted. Here, the defense explicitly explained that the statement was relevant to appellate Adelson's belief, i.e., his mental state at the time of the quote unquote bump, that law enforcement, not his prior extortionists, were behind the contact. And then the part of the transcript is referred to. This was a central factual dispute in the case because the state's theory was that no prior extortion ever occurred, and that the appellant Adelson's payments were part of a murder for hire scheme. By contrast, appellant Adelson maintained that his money reached the killers only because he was being extorted by them in the aftermath of the homicide. Because the statement was not offered for its truth, the hearsay rule does not apply. Alternatively, the statement qualified under we're doing that thing again.
Yeah, if you can read footnote
Oh, okay.
9.
The state argues that the appellant Adelson cannot raise a non-hearsay argument on appeal because at trial, defense counsel related on a hearsay exception, state of mind, to support admissibility. Answer brief at 49. However, the trial court sustained the state's hearsay objection, ruling that the evidence was inadmissible as hearsay. Consequently, that ruling is properly reviewable by this court. It is clear from the record that the proffered evidence was not offered for the truth of the matter asserted, and as such is non-hearsay. The trial court's exclusion of the evidence as hearsay pursuant to the state's hearsay objection cannot be insulated from review as to whether it was hearsay to begin with merely because defense counsel invoked a hearsay exception. A statement excluded as hearsay that is non-hearsay remains reviewable. Additionally, the court's focus on whether appellate Adelson was quote unquote qualified to opine on how extortion quote is done unquote reflects a misunderstanding of the evidentiary purpose for which the evidence was offered. Transcript 1783. Appellate Adelson asserts that this court may review the trial court's determination on this matter. The statement was not being used as an expert opinion or as a factual assertion about extortion practices. Rather, it was offered to illuminate appellate Adelson's subjective perception and his state of mind at the time of the 2016 quote-unquote bump incident, specifically his belief that the people contacting his mother were not the same individuals who had previously extorted him. By insisting on a foundation for quote opinion unquote evidence, the trial court conflated the admissibility standard for expert testimony with the much broader standard for evidence of a party's testimony with much broader standard for evidence of a party's mental state, thereby erroneously excluding highly relevant testimony that bore directly on appellate Adelson's defense theory. the trial court's mischaracterization of the statement as opinion, requiring qualification, deprived the defense of the opportunity to present contemporaneous, corroborating evidence of Appellate Adelson's state of mind, which was both probative and material to a central issue at trial. State of, is
Okay.
this the thing?
So it's then we have to get back to
Oh,
the actual meaning
alternatively,
of the brief.
okay, this rule does not apply. Alternatively, the statement qualified under the state of mind exception as evidence of Appellate Adelson's, quote, then existing mental feeling or belief, unquote. The state argues that Adelson wanted to use his statement to show he had been extorted in the past, but the state of mind exception to the hearsay rule only encompasses future conduct, not prior conduct. See Reed v. State, Florida, 1983. Answer brief at 51. Appellate Adelson respectfully disagrees with the state's characterization. The proffered evidence was a contemporaneous expression of Appellate Adelson's belief as the events of the, quote, bump unfolded. Appellate Adelson's recorded words were made during the 2016, quote, bump, unquote, incident, and therefore squarely fit within Section 98033. Appellate Adelson agrees with the state that a hearsay statement which recounts, quote, observations made previously is by definition an after the fact statement of memory are expressly excluded from the state of mind exception. Answer brief at 51. But that is not the circumstance here. Here, Appellate Adelson did not recount past events reflecting on what he previously thought or experienced, but instead made a contemporaneous expression of belief that law enforcement, not his prior extortionists, were behind the contact and that the time of the bump occurred because of his past experiences with extortion. Nor was Appellate Adelson attempting to use the state of mind exception to explore the state of mind, intention, or motive of anyone other than himself. Answer brief at 52. The state asserts that Appellate Adelson attempted to offer the evidence to prove that Garcia or Magbanawa had extorted him. That characterization is also incorrect. Appellate Adelson's statement was offered solely to show his own contemporaneous beliefs and perceptions, specifically that he understood the individuals contacting his mother during the 2016 bump to be different from the who had previously extorted him. The statement was therefore properly framed as evidence of Appellate Adelson's state of mind, not as evidence of another person's actions, intentions, or motives. But this observation is directly tied to the statement's role in supporting the defense because it captured Appellate Adelson's immediate perception during the 2016 bump. The recording independently corroborated the defense theory that he had been previously extorted by Dan Markel's killers. Importantly, as he explained above, the statement was not offered to prove that Garcia or Magbanawa actually extorted him. Rather, it was offered to show that in 2016, Appellate Adelson made a contemporaneous statement acknowledging that he had been extorted. The timing is significant because it occurred many years before his arrest, long before any motive to fabricate, and thus it carried exceptional evidentiary weight. Unlike testimony presented years later at trial, the recorded statement reflected Appellate Adelson's contemporaneous understanding of events that lent credibility to his account. By excluding this evidence, the jury was left with only Appellate Adelson's trial testimony without the benefit of a contemporaneous record affirming his claims. Nadine, you're up, girl. I cannot.
I'm sorry. Do you
We're
guys
almost
need a
there.
break or something? You need
No,
some
we're
water?
almost done.
No, I was when you told me it was only 10 more pages, I'm like, we're doing it.
Yeah, let's get
But
through
by
it.
the
Thank you,
way,
guys.
I don't like that argument, that repetitive argument either, because
Yeah.
all we're doing is saying the jury should have believed us, not them. What that's
Yeah, I don't
Believe
think
this
that would have
ridiculous
helped.
extortion nonsense.
Yeah, I mean, it just highlights how stupid the
no,
theory
but it's
was.
not how Charlie talks. Like, hey man, I know everything. It wasn't. It's not done
Yeah.
like the way I was extorted. It's not done
Yeah,
like
come
this. I
on.
know everything, right?
Yeah. Yeah.
Okay, footnote
Okay.
10. Once again, the state highlighted this in closing, arguing multiple times that there is no evidence of the extortion and that appellant Adelson made it up as a defense for trial. Ms. Kappelman, he doesn't say no, I have no general idea what you're talking about. He says, all right. He absolutely does have a general idea what she's talking about. And if they were innocent, as the defense has, sorry, if they were innocent, as the defendant has claimed, and this was, in fact, a second extortion attempt, there is not a reason in the world why they wouldn't just say that. I got approached by another one. One came and paid me a visit today. It's happening again. That's crazy. That's his response. And I'm not adding the emphasis on that syllable. He says it like that. Had the jury heard the statement, it would have materially
Oh,
influenced.
you're
Oh,
still in
that's
the
crazy. Sorry.
footnote. Yeah, go
Footnote.
ahead.
That's crazy. Why is it crazy? You're already being extorted by Latin King members. Remember, Doctor? It's because he hadn't come up with that part yet. Emphasis added. But at no point does he acknowledge the first extortion in the Dolce Vita meeting. Why not? Oh, because she asked me not to talk about it. Well, times have changed. There's a second extortion effort now, and they're approaching my mother. You think I'm not going to mention the first extortion? Your people have been running their mouths, and now they've tracked down my mother. You need to get this under control. Nothing like that. He's explaining to her the problems with paying a potential extortionist. What he doesn't say, which is what you expect if he'd been getting extorted for 2 years, is Garcia, or whoever you've been giving money to, has obviously been running their mouths, and now they are messing with my mother. The defendant, hoping it's the police and saying, quote, these people only know part of the story, or they think they know part of the story. The defense picks that out and says, oh, there he is talking about the first extortion. Or is he saying, why did they go to my mom instead of me? So had the jury heard the statement, it would have materially influenced their evaluation of his credibility and the plausibility of the defense. This demonstrates that the erroneous exclusion of the evidence was highly prejudicial and undermined appellant Adelson's right to a fair trial. As in Claim 3, the error was not harmless because the subject of the error was highlighted and emphasized by the state during closing. See Martinez, Allen, blah, blah, blah. Additionally, as in Claim 3, the fact that appellant Adelson testified to the content of the excluded evidence did not render its exclusion harmless, because appellant Adelson's own testimony is no substitute for contemporaneous documentary evidence that objectively corroborates the theory of defense. Jurors could reasonably view a defendant's testimony as inherently self-interested. This is a repeat.
Right. They did this a few times.
Whereas the recording itself would have provided independent, contemporaneous proof of his state of mind and shown that in 2016, long before his arrest for these offenses, appellant Adelson made a statement indicating a previous extortion. This would have rebutted the state's claims that appellant Adelson made up the extortion defense, which was a theme during closing argument. The state makes an additional argument, specifically that, quote, other phone calls between Adelson, Magbanawa, and Garcia disproved Adelson's story about being extorted, unquote. Answer brief at 53. This argument does not engage with the critical evidentiary considerations at issue. The existence of contrary evidence in the record does not render otherwise admissible evidence inadmissible. Evidence that supports a party's theory is not negated, and its exclusion is not harmless, simply because other evidence might appear inconsistent or contradictory. Rather, it is the jury's role to weigh conflicting evidence and assess credibility. Moreover, the exclusion of Appellant Adelson's contemporaneous statement in the face of admitted evidence that could be interpreted against him actually exacerbates the prejudice. By denying the jury access to the 2016 recording at issue, while allowing other calls to be admitted, the trial court deprived the defense of an important tool to corroborate the theory of defense with Appellant Adelson's perception at the time, to allow the jury to fully evaluate the credibility and plausibility of his account. In other words, the exclusion did not merely prevent repetition of evidence, it eliminated uniquely probative, corroborating testimony that was essential to the defense theory. Accordingly, for the reasons set forth above, the trial court erred by excluding Appellant Adelson's statement from the 2016 recorded phone call. The improper exclusion of the call resulted in a violation of Appellant Adelson's constitutional right to a fair trial. See U.S. Constitution Amendments, blah, 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 blah. Appellant Adelson is therefore entitled to a new trial.
Do you notice a lot of Command C, Command V things happening in all of these sections?
It looks like it's Roman numerals.
They're copying a lot of their own stuff.
Oh, yeah, just repeating text. Yeah.
Yeah, they just go, "Ooh, that'll sound good." Command, highlight Command C, and then.
That's what you mean. Yeah.
Oh, okay.
Copy paste. Yeah.
A lot of that, I think. Anyway, I'm also reading the chat. You have really great community, Judy.
Yeah. Thank you guys for still caring. I mean, this is kind of dry and boring, and I feel like my head is spinning when we went over that hearsay footnote. So I'm gonna have to look it over tomorrow after I have a good night's sleep.
You never have a good night's sleep. What are you talking about?
Well, I'll try, but Joe Patuto is going to come on tomorrow night, so we'll expect her to just give us a breakdown.
Oh, yeah.
We don't have to go crazy trying to interpret this stuff.
Oh, I love the way she says it like it is. And
yeah, she's a great teacher.
She's fearless about calling it the way she sees it.
Yeah, it's pretty cool. Okay, go ahead and read
number
5. Go to sleep soon. Thank you.
Number 5, the errors cumulatively, in this case, denied Appellate Adelson his constitutional right to a fair trial. Appellate Adelson asserts that, in light of the errors set forth above, he was denied his constitutional right to a fair trial. CSU U.S. Constitution Amendments 514, 1 and 9, Florida Constitution. So I guess they have a whole bunch. The state's contention that Appellate Adelson's cumulative error claim fails because his individual claims are allegedly, quote, procedurally barred, meritless, or both, unquote, answer brief at 54, misinterprets the nature and impact of the errors. Claims 1 and 2 cumulatively affected Appellate Adelson's right to a fair and impartial jury in violation of both the United States Constitution and the Florida Constitution. Claim 1 demonstrates the trial court erred by denying Appellate Adelson's motion for a change of venue despite pervasive community-wide pretrial publicity and a veneer saturated with preconceived opinions of guilt. Claim 2 shows that the trial court compounded this error by refusing to strike the veneer panel after multiple prospective jurors engaged in discussions about the case violation of explicit court instructions. Taken together, these errors materially undermine the fairness of the trial because not only was the jury drawn from a prejudiced community, but that prejudice was actively reinforced through juror misconduct that went unremedied. The cumulative effort of these errors deprived appellate Adelson of the constitutional guarantees of due process and trial by an impartial jury, and the evidentiary errors explained in claims 3 and 4 cumulatively deprived appellate Adelson of critical evidence central to his defense. The exclusion of the composite text message exhibit prevented the jury from seeing that communications between appellate Adelson and the alleged co-conspirators during the relevant period were ordinary non-criminal exchanges, directly contradicting the state's theory that contemporaneous phone activity reflected conspiracy, solicitation, and coordination to carry out the murder. Simultaneously, the trial court's exclusion of the recorded 2016 phone call barred the jury from hearing appellate Adelson's contemporaneous expression of belief that the people confronting his mother were not the same individuals who had previously extorted him following Dan Markel's murder. Together, these rulings silence the most direct contemporaneous evidence of appellate Adelson's state of mind, leaving the jury with only selective inferences and post hoc testimony that could be viewed as self-serving. These errors went to the heart of the defense, undercutting appellate Adelson's ability to challenge the state's narrative and to present a complete and constitutionally adequate defense, particularly because the state capitalized on the errors, relied on the evidentiary gaps in its closing argument, asserting both that, number one, the pattern of phone calls that it was permitted to introduce demonstrated that the alleged co-conspirators were actively planning and discussing the murder, and the excluded text messages would have rebutted this. And number two, appellate Adelson's testimony about prior extortion was fabricated for trial, and the excluded phone call would have provided 2016 evidence mentioning appellate Adelson's state of mind relevant to the extortion defense. By holding appellate Adelson's trial in a venue permeated with pretrial publicity and community bias, requiring jury selection from a pool influenced by those biases, and excluding both the composite text messages demonstrating ordinary non-criminal communications to rebut the state's evidence and the contemporaneous recorded statement reflecting appellate Adelson's state of mind relevant to the defense, and long before he would have needed to, quote, come up with the extortion defense, the trial court deprived appellate Adelson of a fair opportunity to prevent his defense, which undermines confidence in the outcome. Appellate Adelson asserts each of these errors, standing alone, rises to the level of reversible error. But if the court determines otherwise, then certainly the cumulative error of the errors denied appellate Adelson a fair and impartial trial. See Broomfeld v. State from citing, this case that cites a different case, Slagle v. State from 2011. That's interesting. It's like, hey, they used it successfully. We don't know. Conclusion. Accordingly, for the reasons set forth above and contained in initial brief, the appropriate remedy for all claims is a reversal of appellate Adelson's convictions and a remand with directions that the trial court conduct a new trial.
Yay! We're done. Thank you. Thank you guys so much.
It ended so quickly.
Huh?
No, you know what I mean, Nadine? It's like
You were expecting more.
Yeah, it's like they just regurgitated again
Over and over and over again.
So it's just a
Gosh.
change of venue. The jury was tainted. You didn't allow these irrelevant
The
text
text.
messages in, and this phone call where he supposedly referred to the prior extortion.
But he was on the stand for like 2 days and nobody
Yeah.
believed him. So what's up with that part?
Yeah.
I don't think he actually referred to any extortion. It's just like when he testified that at the Matsuri restaurant with his father when he whispered in his ear. That's what he told him.
That was such a laughable thing to say. Like, he thinks
Exactly.
people are going to believe that bull crap. Like,
Oh,
oh, it's because I whispered it to my dad.
yes, he's delusional. That's the problem with these
Well,
people.
that's terrible for you.
Yeah.
What do you mean? It
Yeah.
could have been recorded.
Yeah, it just so
Yeah.
happens the only time
You whispered to your
you
dad.
said anything, it's not picked up on the surveillance.
Yeah. These
So-
people are crazy.
remember,
It's just
he was-
incredible.
He argued with Georgia that it wasn't blackmail, it was extortion. So he did talk about the extortion.
Because his mommy had looked up the difference. She had looked up what the difference between extortion and blackmail
She was.
was.
Like, Googling.
Yes, she was Googling it.
Yeah.
So
man.
he knew.
Harvey's devices, probably.
Yeah.
So,
So
well,
how
that
you-
was in her trial that she had. Georgia brought that up that she asked Wendy, why would your mom? Did she ask Wendy or did she ask him? I don't know, but Georgia
What?
brought it up that she was Googling the difference between extortion
I
versus
thought
blackmail.
They found it just by looking up her Google history.
Yeah, but Georgia brought it up. Maybe in
Oh.
her closing or something, but she's like, yeah, she's Googling what's the difference.
Yeah.
I miss Georgia. I hope to hear from her very soon. Watching.
By Thanksgiving, they're gonna arrest
That's-
Wendy.
That's what Dave Ehrenberg kept saying. Dave Ehrenberg still seems very optimistic. He was just on STS, and they had this other new attorney from Los Angeles. I
Nemi.
kind of feel like he just doesn't know the case that well because I've never heard of him
You mean-
before.
He's on Law and Crime. He usually comments about it on Law and Crime or one of those other shows.
No,
But
Yeah.
he's
Josh
from
Ritter.
California.
Yeah.
Josh Ritter, he's on Joel a lot.
Yeah, he's from California too.
Yeah.
But he's not 100% familiar with the case, but he's been commenting on it for a while now.
Dave Ehrenberg was Dan's friend
hmm
and a state's attorney.
In
Mhm.
Palm Beach. Yeah.
And he's just like also fearless about saying she's guilty and arrest. I mean, he's like, she'll
Like
be
she
arrested.
should be arrested, and he thinks it'll happen by Thanksgiving. So,
First, he said within
hope so.
30 days of Donna's sentencing, which
Which-
hasn't lapsed yet.
I would
And then he was saying by Thanksgiving, he thinks.
yeah.
But I think even if it doesn't happen by then, it's still going to happen. They probably just need to breathe and regroup and get the case against Wendy set because it's not going to be the same case as the other two.
Well, it's not the same case, and she probably has a decent attorney.
She's going to have a good
So
attorney, I'm
that
sure.
hasn't happened yet.
And she's going to
and-
throw everything at them and try to drag it out in pretrial motions.
Good. Good.
And
Let her
yeah.
stay in jail. Yes.
But
No,
I do think she will get arrested at some point.
Yeah.
It may not be as quickly as we want to see it. But it is what specifically that we know of, because I'm sure there may be evidence, like Jackie thinks they have a smoking gun against Wendy. But I'm thinking of the evidence we know of from the prior trials, what specifically points to her taking action to further the conspiracy. One, she texted Dan to confirm he was going to be in town for his murder.
Mhm.
She asked him about the specific date, and she
Yes.
did it when she was down there at with her
Parents'
family.
condo.
Yes, for Harvey's
Mhm.
birthday, right? So it was in between the two trips, between
And
the
she
June trip.
canceled the vacation with Jeff Lacasse.
Yeah, but that's not
that was for July 18th.
for the conspiracy. What she did to further the
Oh.
conspiracy is she confirmed he was going to be there. So that's like gathering information, getting the intelligence so
Mhm.
they can plan it. And what else did she do? She tried to
Well,
frame Jeff
Frame him,
Lacasse.
yeah, setting up all that stuff so that Jeff would become a person of interest.
And specifically what she did is she texted Rob a photo and lied to him about the fact that her parents don't know about Jeff,
Yeah, the
which was a
secret
blatant
boyfriend.
lie.
Mhm.
And there's only
So
one reason
weird.
she would do that at the
Mhm.
time that she did it, which was at
to
the
make
end of June.
Jeff a suspect for sure.
Exactly.
Yeah.
And so that is furthering the conspiracy. Trying to think what else
Well,
she was
I'm
involved
sure,
in the TV
yeah, the TV
All of her,
stupid
alibi.
alibi.
all of her alibis all day with the writing of this and and looking like a hot mess to go to an unplanned lunch.
Yeah, but those I don't want to muddy the waters with the millions of, coincidences that point to her knowing. Looking at specific evidence that she took action to further the conspiracy.
Hmm.
Because just
Yes.
knowing about it is not enough, I
Right.
don't think.
Yeah.
Going back to what Wendy was up to, I think she planned everything. And if you think about Donna's emails, Donna was willing to emotionally torture Dan. Wendy's the one that refused to make any of those things happen and did not want him to have the money. And I think that angle could be played as conceptual on her part of planning this murder and manipulating her family to go to the, nth degree to
I've
make.
always looked at the fact that when Donna was talking about offering Dan the $1 million, like a third from all of them, she was like, "No, I don't want to do that," but she was willing to go along with having him killed.
Hmm.
Okay, so she's not going to give him $333,000 from her.
Or that's whatever she took out of their account that she wasn't supposed
Right. She wasn't giving him any money, but she was willing to go along with this scheme to have him, unalived.
to.
And
Right.
that to me tells you everything you need to know about Wendy Adelson.
Hmm.
So, yeah, but I think that those are right now from what we know, the active thing she did that played a role in furthering. Somebody also in the chat mentioned Donna had to have gotten Dan's license plate from her, and I agree with that.
Yes.
Donna didn't go to Tallahassee and, follow Dan around to get his license
Yeah.
plate number. Wendy gave that to her.
Hmm.
And there's
Yeah.
only one reason she had that.
Dan Rashbaum gave it to the prosecutor.
Right?
Yeah. Well, you know what? Also, I I also suspect that the morning of the murder, Wendy was also giving those fine details to Charlie. Because why would she need to be in touch with Charlie
For 18
that
minutes about a
morning?
broken
Yeah,
screen
that should I repair it
that she had
or should
sitting
I
for over a
replace
month.
it? Ooh,
That's the
you
other
know,
thing. She had this broken TV that
yeah,
she
just
probably
sitting
whacked with a
there.
hammer,
Hmm.
sitting there for over a month. Jeff is offering to buy her a new TV, buy her a new one. She can
Yeah,
definitely buy herself a million TVs.
yeah.
Why is this one sitting there for a month for the
Hmm.
Geek Squad to come look at?
Yeah,
And why did
exactly. It's
and
so
why did she
obvious.
tell that the tech about the
The
joke
hitman joke.
immediately? And why did
Exactly.
she keep him there for 45 minutes when it was like it should have been a 5-minute visit? She
Yeah,
was like panicking.
or
She
less.
knew he came too early and the murder's not supposed, I mean, the
Right.
thing is not supposed to happen.
I
Yeah.
do believe she almost said hitman on the witness stand. I think
Hmm.
it was at Charlie's trial,
Yeah,
and
she kind
she
of
she was like,
paused.
when the
Yeah,
Geek Squad guy, like, I was like,
yeah,
yes, she was about to say the hitman.
yeah. That was weird. I gotta go find
Freudian
that
slip.
again. Yeah. Well, unfortunately, I gotta go. I'm just so exhausted, and I still
Thanks
have
to
work
everybody
stuff
in the
that I haven't
chat.
finished today. So, yeah,
We
but
got
I
through
really,
it.
We
yeah, you
did.
guys did it. Thank you so much. You guys are the best because this was totally last minute when I got the brief this morning, and I was like, Nadine, please, can you help? I asked Remy also, but poor guy, he's still healing from his dental issues.
Oh, plus
So,
he
yeah.
had probably had a lot of Halloween things to do.
Oh, I
That's
don't know.
that's his that's his type of writing. Like,
Oh yeah, the
Mm.
horror writing. No, I think he said it was because of his dental
poor guy.
surgery and stuff, so he can't really talk too much. So he'll come back in February or something. So he's still out there. Um, okay. Well, so thank you guys so much. Hope you'll
Bye.
come back tomorrow, 7 p.m. with
Yes.
Professor
W
Patuto.
for Wendy's arrest.
Yes,
Yes,
for
yes, we're
sure.
still, keep hope
Is
alive.
it
Keep
3?
hope
Yeah.
alive. Gosh.
Okay.
Okay, justice for Dan.
Have a
Justice
great
for
day.
Dan.
Have a
Bye,
good evening.
everybody.
Bye
Thank you
bye.
guys.